Friends, welcome to the 259th session of Legal Empowerment Through Interaction lecture series. In this journey of discovery, enlightenment, and interaction, we have been exposed to different thoughts, ideas, and the nuances of law was being, or rather is being examined in detail. We have a wonderful speaker today who had enthralled us in the earlier sessions and who have been a part of our family. And had it not been for the new assignment, I'm sure that you would have spent more time with us. Now, of course, he is held up with the new assignment. And likewise, to introduce the subject, we have another family member of ours, and he has taken up new assignment, which keeps him busy, I believe. So we often miss these two wonderful speakers, erudite speakers on our platform, but it's wonderful that both of them came together today on this 259th session on a wonderful topic. Yesterday, we had section 49 and effect of non-registration of compulsorily registrable documents. Today, we are on an extended platform when we'll dilate a bit and we'll touch upon this crucial topic of rules of evidence and courtroom practices in receiving oral and documentary evidence. Today's speaker, Justice Seetharama Murti, sir. Welcome, sir. And also Justice K. Abraham Mathew, sir, who will be introducing the topic, and Justice Ramakrishnan, sir. Thank you for being part of this journey. And all of you wonderful participants, a warm welcome on this Sunday morning. And this being a thoroughly informal platform where we don't waste time on any embellishments, formalities, and things like that. Let us go straight to Justice K. Abraham Mathew, sir, for the introductory remarks. Over to you, sir.
Thank you, Mr. Shyam. Good morning, each and everyone. My brother Justice Murti, Ramakrishna sir, and other friends. Today is Sunday, so I will be available only for a few minutes. This is the most interesting subject. This law of evidence itself is a very interesting subject so far as a judge or advocate are concerned. So I would have been happy to attend the discussion throughout, but I am unfortunate that I am not able to attend it completely. Okay, after my introduction, I will just leave with your permission. So what is the importance of this Indian Evidence Act? Indian Evidence Act. What is its significance? So far as a trial lawyer or any advocate is concerned, is the most important piece of legislation. Many good cases have been lost because of the lack of knowledge of advocates in this law of evidence. Likewise, many bad cases have been won because of the deep knowledge of the advocate in this law of evidence. So that is the significance of Indian Evidence Act, or we say that law of evidence, which takes in not only Indian Evidence Act, but rules of evidence contained in other statutes also. Okay. So far as a lawyer is concerned or a judge is concerned, he must always ask three questions himself. What, how, and why? The answer to the first questions, what and how, you may sometimes get in the statute itself. But the answer to the third question, why, you may not get the answer in the statute. You will have to find it out yourself. This is the role of a teacher or any person who likes to share his knowledge with others in this field. In this Indian Evidence Act, every word or term is very important. We have to a person who wants to gain mastery over this Indian Evidence Act or law of evidence must gain mastery over it. It's a must for him. So what's the difference between evidence and proof? That should be the first question we must ask, because it is Indian Evidence Act, but in many sections we see proof. Then what's the difference? And proved also, the definition of proved also is very important. What's the meaning of oral evidence? Oral evidence. Today we are dealing with oral evidence and documentary evidence. What is the real sense in which the word hearsay is used, the term? Because the Supreme Court has said that the term hearsay is used in different senses. So we cannot have a definite definition for it. Then another question we have to ask ourselves is, is a copy of a document, which is a secondary evidence. A document. In what sense the term document is used in the Indian Evidence Act? Then, suppose under Section 63 we know that oral accounts of a person who himself has seen a document is also a secondary evidence. It's not a copy, it is only a question of it is only oral accounts. That means oral evidence. So once that oral evidence is given, does it become a documentary evidence? Documentary evidence. Because you know that this Section 63 comes under the heading documentary evidence, not oral evidence. So what is the significance? What is the nexus between these oral accounts of a person who himself has seen it and this documentary evidence? Can we call it a documentary evidence once the evidence of this particular person is given? Okay. Another question we have to ask ourselves is how a document may be made part of the evidence in the case. Unless a document is made part of the evidence in the case, it does not become evidence. That means merely because it is available in the file, case file, it does not become evidence because a document cannot prove itself. Somebody has to prove it. That means a document has to be proved by a process known to law. So unless it is proved by a process known to law, he cannot have that status of a documentary evidence. It may be a document, but it's not a documentary evidence. So what are the processes known to law by which a document may be made part of the evidence in the case? We all know it. We can tender it through evidence, through a witness. Then with consent, we can make it a part of the evidence, consent of the parties. Then there is a third one, that is a statutory provision like Order 26, Rule 10, then 293, etc., CRPs, etc. So these are the three processes known to law to make a document part of the evidence in the case. So does a carbon copy of a document become part of evidence? Or we say that a certified copy of a document, certified document of a public document or say private document in some cases, become part of the evidence by its production alone. Because sometimes I think there is a misunderstanding in the legal profession that Section 64 Evidence Act deals with proof of the document because the heading itself is misleading. See this section. It is actually misleading. The section says, headings you see, proof of documents by primary evidence. It does not say proof of documents. It says proof of documents by primary evidence. Documents must be proved by primary evidence except in the cases hereinafter mentioned. That means the ordinary rule is proof of documents by producing primary evidence. And in exceptional cases, secondary evidence may be adduced. That's all what it says. Then, how can you prove the contents of a document? Section 64 does not say, how can you prove contents of a document? It only says what can be produced, what should be produced. So, we are now going to Section 67. Section 67 says how the contents of a document can be proved. He says you can prove the contents of a document by proving the signature or handwriting. What does it mean? Section 64 only says what should be produced. Primary evidence, ordinary rule, and secondary evidence exception. And it is actually Section 67 which says how a document should be proved. Section 64 does not say how a document should be proved. It only says what should be produced. What should be produced. So that's the difference between Section 64 and 67 as I understand those sections. So it means that in the case of proof of documents, there are two stages. One, production of a document. Second, the manner in which it should be proved, how to prove it. So Section 64 only deals with the first stage, that what should be produced. Section 67 deals with the second stage, how to prove it. These are all what is what can be seen from this sections 64 and 67. Then what's the difference between relevancy and admissibility? A document may be relevant, but it may not be admissible. Then what's the difference between relevancy and admissibility? How a document which is relevant becomes inadmissible? We know that this admissibility is dealt with, or we call it mode of proof. Mode of proof. And relevancy is a different thing. There are two distinct phrases actually. So these are the matters which require answer for a person who wants to have deep knowledge in law of evidence. Otherwise, actually, we are only dealing with this statutory provisions. I think
Charger.
Brother Justice Murti, I have known him for many years. He was director of the Andhra Pradesh Judicial Academy. When I was director of the Kerala Judicial Academy, we met at National Judicial Academy at Bhopal. He is a veteran in this field, so he is a very good teacher also. He is a very efficient judge also. He will be able to throw much light on this aspect, but I am sorry to say that the time is very limited for him. I don't know how much he will be able to deal with this subject. What sections, which sections he can deal with today, I don't know, because the time is very limited for him. But within this limited time, I think he will be able to enlighten us. So welcome, Murti sir. Thank you very much.
Thank you, Justice Abraham Mathew, sir. It was indeed wonderful. And a fine gesture on your part that on Sunday morning, in spite of your busy schedule, you were able to be part of the family and share your thoughts on this very important topic. I'm sure that the subject is very dear to your heart, and that's why I insisted that you should come, whether it be for a short period or otherwise. Thank you very much for your presence, valuable presence and input, sir.
Thank you.
Now, over to you, sir. Murti, sir, all yours.
In the first place, thank you, Abraham, sir. I have got high regard for you for the nice words. Thank you so much. To the august audience, first of all, my sincere apologies for not being able to be with you, and my inability to associate with the learned group of the learned seniors and also upcoming youngsters. As rightly said, there is a calamity in my house in July. My eldest brother, who is a leading lawyer of my town, died of massive heart attack. We were helping his son and daughter, and therefore I'm moving from Hyderabad to my native place, Kakinada. And secondly, I'm now working from Kurnool, which is 2.5 hours drive away from Hyderabad. My family is at Hyderabad. So some weekends I'm coming to Hyderabad, some weekends, depending upon the pressure of the work and volume of the work, I'm staying at Kurnool. Therefore, I'm not able to join. Though sometimes I was very much interested to join some of the meetings and learn from the speakers. Anyhow, let me come to the topic. I once again thank the organizers for giving me one more opportunity to be with you and share my humble thoughts on today's topic. Courtroom practices. These are very, very important, apart from rules of evidence, in the matter of receiving oral and documentary evidence. So we may start with trial, because the pleadings are complete. If it is a civil case, let us assume the issues are framed. It's a criminal case where charges are necessary, charges are also framed. So the matters are now posted for trial. We are at that stage. From that stage, the production of evidence comes. I have earlier shared my thoughts on the topic documentary evidence, kinds of documents, marking of documents, relevancy, admissibility, impounding, privileges attached to the documents. I have been called upon to speak, and I thought I gave a detailed account of my thoughts on that topic. Maybe slightly there may be some overlapping when we discuss the present day topic, namely rules of evidence and courtroom practices in receiving oral and documentary evidence. See, when we see the Indian Evidence Act, the frame of the Act. It has 3 parts. Part 1 has 2 chapters. Chapter 1 only consists of 4 sections. Apart from title and extent of jurisdiction, 2 important sections are there. One is interpretation clause, proved, not proved, disproved, something to do with proof, and then another section is presumptions. Chapter 2 is important today. It deals with relevancy of facts. As our Abraham sir is saying, relevancy and admissibility, we have to examine juxtaposition. Because experts say that when we come to relevancy, admissibility is presupposed. Then part 3 deals with proof. I don't think we will go into that aspect because only we are dealing with receiving evidence, not appreciation of evidence. Of course, if necessary, we will deal with some aspects of proof also if necessary and if the time permits. Then chapter 3 deals with facts which need not be proved, that is sections 56 to 57 and also 58. Then Justice Abraham sir also saying about oral and documentary evidence. What is oral evidence? Chapter 4, 59 and 62 sections. But the gamut is very large. Chapter 5, documentary evidence. Section 61 to 90, abortion. Then chapter 6, impliedly covering both oral and documentary evidence because exclusion of oral evidence by documentary evidence. Section 91 to 100. Then part 3 is production and effect of evidence. There are about chapters 7 to 11 in that. Chapter 7 deals with burden of proof. We have already seen the distinction between burden of proof and onus of proof in the earlier sessions. This topic was discussed by a number of speakers already. Chapter 8 is estoppel, sections 1215 to 117. Chapter 9 is competency and compatibility of witnesses. We may slightly cover some aspects in this chapter, sections 118 to 134. Chapter 10 is examination of witnesses, sections 135 to 166, chief examination, cross-examination, re-examination. And then chapter 11 is important one, section 167, only one section, improper admission and rejection of evidence. Starting with oral evidence. Section 59 says very lucidly, all facts except contents of documents may be proved by oral evidence. Then oral evidence can be given of what is the fact, given of facts what are perceived by the 5 senses. My favorite saying so far as the senses is concerned is Drusya, Sravana, Sparsha, Rasa, Gandha. These are the 5 senses by which facts are perceived. Whoever perceives these facts by use of these senses is entitled to give oral evidence of those facts which are perceived. But any witness is not supposed to give opinions except when he is called upon to give an opinion, like an expert. Therefore, it is said, oral evidence must be direct and must be given by the person who perceived the facts by his senses, and he cannot give opinions. He cannot also give oral evidence because oral evidence must be direct. Then what is hearsay evidence? Before I go to hearsay evidence, the leading decision that a witness is not supposed to say opinion, but he is supposed to give the facts perceived by him is AR 1957 Supreme Court 857. AR 1957 Supreme Court 857, Mubarak Ali's case. A witness is supposed to speak of facts perceived by him by his senses, but shall not give opinion. Opinion is inadmissible unless he is an expert called upon to give an opinion. Then, so far as hearsay evidence, there is no hard and fast rule that in all cases hearsay evidence is inadmissible. There are instances where hearsay evidence is also admissible. We call them exceptions to the oral evidence rule. Though it is said hearsay evidence is no evidence, there are 6 exceptions. if any evidence falls under these 6 exceptions, the judge is entitled to receive it in evidence. One is res geste, the other is admissions and confessions. One is a genus, the other is a species. Then statements under section 32 of the Indian Evidence Act, third category. Then fourth category is evidence given in formal proceedings. Fifth category is statements in public documents. And then the last category is provisos to sections 1 and 2 of section 60. These are the exceptions. Then when it comes to receiving evidence, what evidence shall be given? The question is, evidence of what? As we know, in all legal proceedings, all the rights and liabilities of the parties necessarily arise out of facts. That is why fact is defined in the Indian Evidence Act, section 3. And then we come across facts of two kinds at the time of receiving evidence. One is physical fact, the other is a psychological fact. Physical fact, we know, is anything or a state of thing capable of being perceived by senses. A thing is hot, air is cold. All these things are perceived by senses. They are physical facts, though they are not visible because they are perceived by senses. Then psychological facts are those which cannot be perceived by senses, but evidence of it can be given. Like, for example, intention to commit an offense. It's a psychological fact. It is not subject to perception by bodily senses, but they are subject to consciousness. So therefore, these facts also can be admitted while receiving evidence. Then receiving and admitting instruments and documents. Instruments are those are chargeable with duty. Such documents, we call them specifically as per the statute as instruments. And other documents which are not chargeable with duty are generally called as documents. These two kinds of documents or instruments also can be received in evidence, subject to the other rules of evidence. Then receiving documents in evidence is different from producing documents. Documents are produced along with the pleadings as per the present amended law. The documents are already in the record. But when a document is received in evidence or oral evidence is received in evidence, it becomes a part of the evidence. So far as documents are concerned, the general practice is to call documents which are already received in evidence as filed documents. The other documents which are produced and are in the record but are not exhibited, they are known as unfiled documents. This is the practice in both the states of Andhra Pradesh and also Telangana. I think the same practice is uniformly followed in all the courts in the country. The documents are already on record because parties produced documents with the pleadings. But the documents are not yet received in the evidence, they are part of the record. These documents are of two kinds. Some documents may not be marked at all through the witnesses, leave alone proof. Mere marking of a document is not proof, as we all know. So some documents are left alone in the record without even being touched in evidence, but some documents are received in evidence through witnesses. Documents which are received on record through witnesses and are exhibited are known as filed documents, and the remaining documents are known as unfiled documents. Then different kinds of documents. Documents which are compulsorily attestable. Then primary evidence and secondary evidence, that means the original and also copy. Because Mr. Justice Abraham sir referred about these documents while dealing with the primary and secondary evidence, he was also saying when a oral account is given of a document, because it is also a part of the secondary evidence coming under the chapter documentary evidence, can it be said that oral evidence can be documentary evidence? Let us see the situations in which the secondary evidence can be given. Let us refer to section 63. It is stated secondary evidence means and includes. There are 5 categories there. Then we come to section 65, which says cases in which secondary evidence relating to documents may be given. There are 8 A to G there. Please carefully see at your leisure all these categories. I'll point out categories A, C, and D, or clauses A, C, and D. Any secondary evidence of the contents of these documents is admissible. Carefully see. So far as B, only written admission is admissible. So far as B, only written admission is admissible. So far as E and F, certified copies are admissible, but no other kind. That is my humble view of the matter. E and F, only certified copy is admissible and no other kind of evidence is admissible. Let us come to G. Let me read that G. This may slightly answer the question subject to further discussion. What is this G? When original consists of numerous accounts or other documents which cannot conveniently be examined in court, and the fact to be proved is the general result of the whole collection. Like in a partition suit or a partnership suit or an account suit, voluminous account books are there. Here, the documents are very much available, but they are voluminous, and only an expert can read and deduce the result of those documents. See, a document is written in a Devanagari script. We have reached a situation nobody can read the script, only a few experts can read it. So in such situations, the person who has seen the document can give evidence. He can say the result of it. So when we go to this G, evidence may be given as to the general result of the document by a person who has examined them. Please mind the word, not seen, examined. Suppose an illiterate sees a document. Can he give a oral account of it? Certainly not. So a person who has examined can give evidence of the contents of the document. So in category G, mostly the documents are available. Maybe they are exhibited in a bunch, but they are so voluminous and some technical expertise is necessary to decipher the contents and deduce the result of the content of the document. Then oral evidence of those documents is permissible under G. This is how we come to secondary evidence. Because I am not in detail dealing with these topics, because I have earlier in my talk dealt with these documents, both primary and secondary evidence. Then I have already mentioned about admission, which is a genus, and a confession, which is a species of it. Admissions again is a oceanic topic. When we say that admitted facts need not be proved and we receive them in evidence just by saying without any cross-examination, then we have to think of the kinds of admissions. Self-serving admissions, are they admissible? Then self-harming admissions. How far they are admissible in a criminal case? and what are the conditions. Then there are also admissions by party, admissions by agent, admission by a counsel. Then also see admission by a partner in crime, accomplice. Similarly, in civil cases, admissions by co-defendant, co-plaintiff, then admissions of wife and husband, admissions of predecessor in interest, admissions before a legal professional. What are the privileges? So these are all the aspects one has to keep in mind. Then coming to confessions, to whom the confession is made, what kind of confessions can be admitted. See, nowadays, we are going to such an extent that I have seen in some POCSO Act cases, even children are being taken to magistrate and their statements are being recorded under 164. What purpose would it serve? Children generally will not be administered any oath. I do not know the practice in the other states, but in our state, both Telangana and Andhra, there is no uniform practice. When 164 statement is being recorded by the magistrate, some magistrates are administering oath, some are not administering oath. Let us examine, let us debate on the point whether oath must be administered or not. If oath is to be administered for a child below 13 years under the Oaths Act, if no oath is to be administered, what is the use of that statement? Supposing that child resides from the statement, are we going to punish him? So whether such statements are receivable in evidence or not, and what is the probative value of such statements? These are some aspects which come to our mind. So of what evidence can be given, we are discussing. Of facts, evidence can be given. Then, when we are discussing about documentary evidence and oral evidence, let us also discuss about slightly Rule 3 of Order 13 of the Code of Civil Procedure, which deals with rejection of irrelevant and inadmissible documents, which says the court may at any stage of the suit reject any document which it considers irrelevant or otherwise inadmissible. So as rightly put, a document may be relevant, but it may be inadmissible. A document may be admissible, it may be not relevant. The same thing applies to oral evidence vis-a-vis. Section 135 deals with Evidence Act, order of production and examination of witnesses. This is also relevant at the time of receiving evidence. Correspondingly, there is a provision, there is an order in the Code of Civil Procedure which says right to begin. Right to begin, Order 18. Then we have got some chapters in CPC, Order 18 and Order 41 also. So this order and the production of order and examination of witnesses is also important when we come to receiving evidence. How this is relevant, we will also see at the appropriate time. So I was first mentioning that relevancy presupposes admissibility. See, a document is written on a white paper, but it is a sale deed. In a suit for declaration of title, a title deed is relevant, but because it is not charged with sufficient duty and is not registered, it is inadmissible. coming to oral evidence, an offense has been committed in Madras, Chennai. But the defense is at the time on the date the offense is committed, the alleged accused is in Kerala. But generally, this may in the first instance, in the first blush, appear to be irrelevant evidence, but it becomes relevant under the Indian Evidence Act. Because for a person in Kerala, it is impossible to commit an offense on the same day at Chennai. So these are the aspects which we generally deal with at the time of receiving oral and documentary evidence. See, the plaintiff has a right to begin. Similarly, the prosecution has an obligation to begin. But in a civil case, when the defendant admits the facts alleged by the plaintiff and contends that either in point of law or on some additional facts alleged by him in his own pleading, that the plaintiff is not entitled to any relief or part of the relief, then because of that pleading and the circumstances, the right to begin shifts to the defendant. So here we are dealing with slightly the onus of proof, the burden to introduce evidence. So at the time of receiving oral and documentary evidence, this aspect has to be kept in mind by the officer receiving evidence. Then the situation may be, there are many issues in a matter. On some, the initial onus is on the plaintiff, and on the other, the initial onus of proof is on the defendant. Then what is to be done? Then on the issues on which the burden lie on the plaintiff, he has to commence, he has the right to begin and adduce evidence. He can, of course, reserve the right to adduce evidence on the other issues on which the burden lay initially on the defendant to adduce evidence later. So here we have to deal with the onus of proof and also the burden of proof. Broadly said, burden of proof is the legal burden which never shifts. Onus of proof is the evidentiary burden which shifts from side to side during the course of evidence. So I mean, when there are several issues, but the burden of proving some is on the plaintiff and the burden of proving the rest on the opposite party, the relevant rule is Order 18, Rule 3. When coming to courtroom practices in this right to begin, in one case, an objection is raised by the defendant that the plaintiff adduced evidence on only 2 issues. He did not adduce evidence on the remaining issues. Therefore, unless the plaintiff completes the adduction of evidence on all the issues, he will not get into box. Then it is for the court to decide as to whether on the remaining issues on which the plaintiff did not adduce evidence, whether the initial onus is on the defendant or the plaintiff. If the initial onus is on the plaintiff, it is the obligation of the plaintiff to complete the evidence and completely adduce evidence on all issues. Otherwise, he will forego the right to adduce evidence on those issues later in rebuttal. Supposing if the court comes to the conclusion that the initial onus on the remaining issues is on the defendants objection will be overruled and the defendants will be called upon to adduce evidence. And then the plaintiff will generally reply on all the issues, and because the right of rebuttal is there on the issues, other issues, remaining issues on which initial onus is on the defendant, he will then adduce evidence after the defendant's evidence is complete. Then the next issue is, there is a suit. A witness gets into box. then the court must be careful and see whether the first witness is a party to the proceedings. Whether the first witness who entered the box is a proceeding, is a party to the proceedings. Because the Rule 3 casts a burden on the court. Supposing, say, for example, a wife files a suit, the husband gets into box. Then the pleading itself shows that the husband is looking after the affairs of the wife. The wife may not be examined. The husband will only speak. Then the husband will be permitted to give evidence. But take a case where the father wants to adduce evidence on behalf of the son. Then the question is whether the son will be later examined who is the plaintiff, because the father is not the party to the suit. Because Rule 3A of the CPC says, if a party wants to appear, later permission must be sought. Permission must be sought. So these are the areas. Simply because a witness is present, the presiding officer shall not be in a hurry to record evidence. He must go through the record. He must come prepared to the bench and see who is to be examined, who is to be not examined, and what is the right to begin, what is the order of examination of the witness. So recording of evidence requires a focus on section 137. Examination in chief, cross-examination and re-examination. See, here there is a very debatable issue. Nowadays, almost the recording of evidence, receiving and oral and document evidence is losing its significance. Chief examination affidavit will be filed. Because the court is otherwise busy, a commissioner will be appointed to record the cross-examination. See, in all affidavits, literally it is only all leading evidence, which is prohibited under the Indian Evidence Act. Let us ponder over, is it necessary with the present value system to go back to the old law by asking the parties to lead examination in chief in open court hall? Otherwise, all kinds of evidence comes on record, that is inadmissible evidence also comes on record. And at the time of appreciation, it will be a Herculean task for the judge to sieve the evidence and separate the inadmissible evidence from admissible evidence. So these are some of the areas on which the presiding officer must be careful. That is why it is always necessary to come prepared to the court. Section 141 says, a leading question is one suggesting the answer. But nowadays, examination in chief in the form of an affidavit, this provision of law has lost its significance. Then what can be the re-examination? It is done before a commissioner. Any kind of re-examination is being permitted, and sometimes any kind of re-examination is not permitted. And then there is a controversy at the time of arguments. So these are the areas where we have to ponder over and think whether we have to go back. Say, for example, a will is there. It's a compulsorily attestable document. An attestar first comes into the box. Then an objection can be raised that an attestar is not the custodian of the document. He cannot produce the document and then mark it and then speak about it. It is for the propounder to first come into the box and then mark the will and then leave it to the attestar to prove the will. So who shall exhibit the document first? from whose custody the document must come on record as a filed document, as an exhibit. Then continuing with the attesters. See, a propounder filed a will. Then he said his father executed the will, and then it is with his uncle. His uncle passed on to the will for filing the suit. That's how the will came into his custody. He will mark the will. Then he will examine the attester as a second witness. The affidavit of the attester is filed. Then the cross-examining counsel is called upon to cross-examine. Then he makes a request. He would like to know whether the other attester or the scribe who is having animus attestendi will be examined as a witness after this witness. Supposing the other witness is attester also is to be examined, the counsel may say he will cross-examine both the attesters at one point of time on a single day, because he does not want to disclose the line of cross-examination to the other attester who is to be examined on a later day. That is a valid request. An experienced trial judge will certainly permit such a request and ask the chief affidavit of the other attestar also to be filed, and then permit cross-examination on the same day. Not even allowing a lunch interval in between. Otherwise, the other witness will be prepared. He will have time to reflect and cover the mistakes of the other witness, mistakes made by the other witness. He will fill up the gaps. Then another aspect, when two attesters are there in the court hall for being examined, a request will be made that the other attestar may not be present in the court when examination of one attestar is going on. It's also a valid request. It's also a valid request because he should not know by sitting in the court hall what the earlier witness is deposing. Then the court may agree with such a request and ask the other attestar to stay away from the court hall so that he may not know the line of cross-examination and be prepared mentally to answer all those questions and fill up the gaps. Similarly, we can take this to criminal side also. Two attestars of a panchnama, two panch witnesses. The same rules apply. The same request can be considered on the same analogy by the court.
Sir, can I just ask one question there, sir?
Yes, sir.
Sir, it is true regarding witnesses. Just imagine there are three defendants. All are to be cross-examined in the same line. When the first defendant is in the box, can the second and third defendant sit in the court? Witnesses, we can ask them to stand out. But if it's a party, can we request them to stand out because they'll say, I am a party and as of right, I can sit in the court?
Sir, I will deal with this on two aspects. See, if it is a chief examination, it's all affidavits, right? They will be filed simultaneously if necessary as ordered by the court. Then when it comes to cross-examination, like let us illustrate, it is a case of injunction by one brother. Two other brothers are the defendants. Their case is there is no partition, whereas the plaintiff says there is a oral partition, therefore he got the plain schedule property exclusively to his right. So when his case is oral partition, if one defendant is cross-examining, the line of cross-examination is the same for both, right? If this defense is taken, oral partition is taken by the defendants 1 and 2. If first defendant files his affidavit and he is being cross-examined by the plaintiff's counsel, the second defendant, if he is to be examined and he engaged as deferent advocate, the line of cross-examination would be the same because almost the defense is the same. then I think it is reasonable, it is just and fair to ask the defendant, a party witness, to be away from the court. That is my humble opinion.
It's
No, not
permissible
that.
and
No,
possible.
even no, if it is a common lawyer and common defense,
Even if it is separate,
you can you can ask you can ask the lawyer as to whom you are going to examine.
both are
also-
examined. Suppose he says he will examine both of them.
Then the question will be, as you said, ask one party to go out.
Yes,
That may
necessary,
require.
because truth shall come out. Ultimately, we are in search of truth.
Sir, why I put this question is because we usually in trial side, we come across this and the party would say that I am a party, so I got a right to sit. You cannot ask me to step out. So that is why I put that question, sir.
But
No, not that. Say, Shyam, in such cases, I think when he is put in the box, you can ask that there is a common defense. You are in court at the time when the other witness was examined. You can discredit the witness that you are changing your stand also. That is possible.
That is true, sir. I mean, usually we say that such and such person is also, we'll see that it's recorded, that such and such person is also here throughout the examination, so that we'll be prepared and fully armed with the answers for the course of cross-examination that I'm going to do. Very well, sir. Thank you. Please go ahead.
let us say, very good question. I have got another thought. I will discuss that also at this stage only.
So,
See, a plaintiff filed a suit against a sister, and the plaintiff relies upon a will. The second defendant is another brother. He supports the plaintiff, says that father executed a will, therefore the sister is not entitled to any right in the father's separate property. So, after the plaintiff is examined, who shall first cross-examine will be the general question. It is not the sister who is the first defendant. People will generally say that the party sailing with the plaintiff will first cross-examine.
the parties who are sailing together, correct?
But my point is, he shall not be allowed to cross-examine. He shall be allowed to do further chief. Otherwise, he will put leading questions and see that the will is proved by the attestors.
Oh,
I
correct.
have rendered a decision as a judge of the Andhra Pradesh High Court that in such situations, he shall not be allowed to cross-examine. He shall be only allowed to fill up the gaps in the chief by doing further examination in chief by not putting the leading questions. How far you will all agree with me, I don't know. But this
Sir, we all agree, sir. But will the presiding officers before whom we say this would agree is the question, sir.
that is why I rendered a decision as a judge of the High Court.
Absolutely, sir.
Now in AP, I think they are following this. Otherwise, what will they say? All leading questions will be put in a witness like attester.
Correct, correct.
What is left to the poor sister to cross-examine?
You need only plant your man as a defendant. That's more than sufficient so that you get an occasion to lead. Correct.
So this aspect also we can ponder over, sir.
Absolutely, sir. Sir, if possible, kindly share the decision of yours, sir, regarding that proposition, because it's very interesting.
I will share, sir. I will share.
Thank you. Thank you.
But the decision I incidentally rendered in a case where the defendant wanted to withdraw his written statement, which is favorable to the plaintiff, and wanted to file a separate written statement. That matter has come up before me, and the trial court did not permit. Then, while confirming that order of the trial court, I said, when these witnesses are examined who are sailing with the plaintiff and who supported the plaintiff shall not cross-examine the plaintiff's witnesses. They must only sail with the plaintiff and then do further examination in chief, but shall not cross-examine.
I mean, very fair and logical, sir. Very fair and logical. But
that decision I will certainly pass on, sir.
correct, sir.
Then, to a piece of oral evidence, an objection is raised that it shall not be recorded. Then what is the duty of the trial court judge? My humble view is he shall record the oral evidence, question and answer form, record the objection and the answer to the objection, and then deal with it at the time of appreciating the evidence and rendering the judgment. Why this is necessary is, supposing he comes to a conclusion this is not admissible or this is not relevant or this shall not be recorded, tomorrow the appellate court comes to the conclusion that such an evidence is not let in, then the party will be handicapped. Supposing the question and answer are there and both the objection and the answer to the objection are there, it is for the trial court, appellate court to appreciate the evidence. This I refer to Rule 11 of Order 18, sir. Rule 11 of Order 18. Which says that the court will take down the question and answer and also the objection with details of the counsel who raised the objection together with the decision thereof. This is also, I think, the view expressed in Bipin Chantilal Panchal's case, 2001 Supreme Court 1158. So when an objection is raised to a piece of oral evidence, my humble view is the question must be recorded, the answer must be recorded, the objection must be recorded, the reply to the objection must be recorded, and the decision thereon shall be recorded. Everything should be on the record, so that if the appellate court disagrees with the trial court, there will be complete evidence on record for appreciation. Then, certain times, before a particular piece of evidence is admitted, the court may require that the admissibility of such evidence may be proved. The court may require that the admissibility of the proposed evidence may be proved, because before admitting that evidence, certain other evidence must be first adduced. Like, for example, a dead person's statement is required to be admitted. A dead person's evidence is required to be admitted. Then the fact that must be proved first is that person is dead. Otherwise, this statement is inadmissible. So, certain times, a previous fact must be proved to make the latter fact admissible. That is Section 104 of the Indian Evidence Act. Section 104 of the Indian Evidence Act. Supposing a dying declaration is to be admitted, the person's death must be first proved. So here, for a little while, I may go back and then come back to relevancy of evidence. So far as relevancy of evidence is concerned, the Evidence Act is very strict. Unless that evidence falls in the categories mentioned in the Evidence Act, it cannot be admitted. It cannot be admitted. What are those relevant sections? Let us analyze. Sections 1 to 7 are the 7 types I have categorized. First clause is sections 6 to 16, dealing with relevancy of facts connected with facts in issue. Relevancy of facts connected with facts in issue. The second category is section 17 to 31, relevancy of admissions and confessions. The third category is sections 32 and 33, dealing with relevancy of statements made by persons who cannot be called as witnesses. The fourth clause is, in my view, sections 34 to 39, dealing with relevancy of statements made under special circumstances. Then 40 to 44, relevancy of judgments. Then 45 to 51, relevancy of opinions. Then 52 to 55, relevancy of character. Unless the evidence is relevant in these 7 types of provisions, the evidence becomes irrelevant. That is what the strict mandate of the Indian Evidence Act is, my view. Then continuing with the discussion. Character evidence. I'm mentioning about the last aspect. Character evidence. Please see section 54 of the Indian Evidence Act. Generally, character evidence is irrelevant even in a criminal case, as prosecution is required to prove the charge as ordained by the cardinal rules of criminal jurisprudence. But then, if already the accused adduced evidence about his good character, then in reply, the evidence of his character by the prosecution is admissible. Then what is character? Character, in my view, has two components. The judge must bear in mind when character evidence is being taken. One is reputation, the other is disposition. Reputation is the credit one has in the estimation of others. It is known to many. But disposition is one thing which is known to persons who are very close to him. A couple may have a very good reputation in the society, but in the house they are quarreling with each other. That is disposition. That is known only privately to a few in the house. So character is a trait which has two components. One is reputation, the other is disposition. Then another courtroom situation, let us go. The plaintiff filed a suit based on a document, and his evidence is that the document is written in the own hand of the defendant. The defendant's defense is it is a forgery. He did not at all write the document. Defendant is in the box. He asserts in his examination in chief that he did not scribe the document, he did not sign the document. He is neither the author of the document nor the signatory to the document. Then the court and the plaintiff tried all methods. There is no other document written by the defendant of comparable standard. There is no document at all. How to prove the handwriting? The intelligent cross-examining counsel, namely the counsel for the plaintiff, with the permission of the court, gives a piece of white paper in the box and dictates a matter and asks him to write that matter, reduce it into writing on that piece of paper. Of course, when the permission is sought and permission is granted, then he dictates some matter and asks the witness to write down the same on a piece of white paper supplied to the witness by the officer of the court. The cross-examining counsel, the plaintiff's counsel, will take care to see that the matter dictated is different, but contains in its content certain specific, distinctive, and peculiar words and figures which are already there in the disputed documents. We all know, sir, it is common knowledge that every writer has his own style of writing. Size of letters, slant of letters, strokes, margins, spacing, height, width, all these things are peculiar to each writer. Then this writing, which is reduced into writing while the defendant in the box is in the box, will be marked as an exhibit. For the court to compare the writing in the document with that of the writing in the piece of paper which is supplied to the defendant in open court hall, or which the defendant has reduced into writing the dictation given by the plaintiff's counsel. Then the question is, what marking is to be given to this document? In my view, it must be marked in the court series, C series. and this will be used as a document by the court for comparison as to whether the writing in the disputed document is that of the defendant or not. This is one wonderful courtroom practice. Then, sir, another practice. The witness is required to produce a document. He is summoned only to produce a document. After he produces the document, the purpose is over. But one of the counsel requests the permission of the court to cross-examine the witness. The question is whether he becomes a witness by mere production of a document. The question is whether he becomes a witness by mere production of the document. My view is no, he cannot be cross-examined. The purpose is he is called upon to produce a document, he produced it. That's all. Please see section 139 of the Indian Evidence Act. Please see section 139 of the Indian Evidence Act. Then a judicial magistrate recorded a statement of a witness. That statement is sought to be relied upon by the prosecutor. Then the accuser says that while recording that statement, the learned magistrate did not follow the procedure. The statement or the deposition is improperly taken by the magistrate, and he wants the magistrate to answer certain questions. He wants the magistrate to answer certain questions. The question is whether the magistrate can be compelled to come to the box and answer those questions. Please see section 121 of the Indian Evidence Act. The magistrate cannot be called upon to answer those questions. If he is to be called upon, it can be done only by a special order of a superior court. It can be done only on the orders of a superior court. So in these areas, while receiving such evidence and refusing to receive such evidence, the presiding officer must be very, very careful. Then I was discussing about custody. It is a very well-known thing. The person who is supposed to have custody can only produce a document, and it can be received in evidence through that witness. Supposing a letter is written by A to B, when there is a proof it is posted, the presumption is it is received. Only B can produce it, nobody else. Supposing B is dead, his son, who is supposed to have custody of the document, can produce it. So custody of the document is also important when we are receiving documentary evidence. Then in a given case, an interesting case has come before me. A list of witnesses is filed by the party, namely the plaintiff. Say there are 6 witnesses in the list. The plaintiff examined 4 witnesses and then closed his evidence. The defendant said, unless the remaining 2 witnesses are examined, I will not commence my evidence. The plaintiff says, I have given up those witnesses. If the defendant wants, he can examine them. What is to be done? Whether the plaintiff can be compelled to examine those witnesses? It is only the discretion of the plaintiff, because the quality of evidence is important and not the number of witnesses. That is section 134 comes into the play for the magistrate to record a finding that the plaintiff cannot be compelled, and the remaining leftover witnesses can, if necessary, and if the defendant so desires, may be examined by the defendant. Then Relevancy is of two types: legal relevancy, logical relevancy. Legal relevancy, I have pointed out 7 types of relevancies by reading out all the sections in the chapter dealing with relevancy. Then what is logical relevancy? Legal relevancy, automatically the evidence is admissible. A fact is said to be logically relevant when that fact appears to be having a bearing on a relevant fact by application of only logic. The latter fact has relevancy with the relevant fact only by application of logic, then it is called logical relevancy. See, we come to this aspect in privileged communications. A communication is made to a counsel. It is relevant only logically, because the law says such evidence is not relevant. It cannot be admitted in evidence. It is a privileged communication. A husband says to wife that he committed an offense. The wife cannot be called as a witness because it's a privileged communication under section 122 of the Indian Evidence Act. Then another point is, A wants to say that he is not the owner of the property when he sold it. In such a situation, in a fact situation, it may appear that such evidence is relevant, but in fact it may not be relevant for the reason that at the time he sold the property, he may not be the owner. But at the point of time he wants to adduce evidence, he became the owner. Like he sold away his father's separate property. He is the only issue, only legal heir. By the time a suit is filed by him, his father died, the property devolved upon him. It is under the principle of doctrine of feeding the grant by estoppel, such evidence is not admissible. It is not relevant. He cannot be allowed to lead evidence that he is not the owner at the time when he sold the property. Another aspect nowadays we are seeing is private experts are mushrooming in every state. FSL is not able to cope up with the work of the courts in giving opinions on forged documents, both in civil and criminal cases, because value system is coming down, offenses are growing, civil and criminal cases are coming up on forged and fake documents. The forensic science laboratories are not able to cope up. Take a case, I'll tell you an illustration. Plaintiff filed a suit on the foot of a promissory note. The basis is a promissory note. The defendant's defense is it's forged. He goes to a private expert and gets an opinion it is forged. He doesn't ask the court to send the documents with comparable standards to an expert and get an opinion. What is the value? What is the admissibility of such evidence? Because when an opinion is sought on a forged document, the importance is on the documents which are of comparable standards. Who is selecting those documents? The defendant is alone selecting those documents. Those are all self-serving documents. He gets an opinion and files the opinion, and wants a witness, the expert, to be examined. Then what is whether we have to admit that evidence, or we have to admit and then leave it for appreciation at the proper time. Let us ponder over this. These cases are coming up in now the state of Andhra Pradesh in good numbers. Who has to choose these documents, namely documents of comparable standard? Is it like an impartial person like a judge, or the parties? Next aspect. In a civil suit or a criminal case, maybe criminal trespass, or a title suit. A neighbor who is having the adjacent property is examined to say that the plaintiff is the owner of the property. To his knowledge, he is in possession, he is a neighbor. He knows the plaintiff enjoying the property. There is no trespass by the accused. On the alleged date, the accused is himself the owner. Since 30 years he is residing there. Because he is a neighbor adjacent owner of the property, he knows all these facts, he gives evidence. Then the question is, in the cross-examination, a question is put, you produce your title deed to show that you are the owner of the neighboring property. Can he be compelled to do so? Section 130 of the Indian Evidence Act says no, he cannot be compelled. Then another intelligent counsel. A party is giving oral evidence. In his cross-examination, he brings out that what all he is deposing as oral evidence is the content of a document. He brings out in the cross-examination. Whatever the witness is saying and whatever oral evidence the witness is giving, such evidence is only a content of a document that is brought out. Then all that evidence is inadmissible. Section 144 of the Indian Evidence Act. Because Justice Abraham sir is saying about this also. A person giving oral account of contents of a document. Is it oral evidence or documentary evidence? I have already dealt with it earlier. Now this is another angle of it. Then in the cross-examination, a witness can be confronted with any document. With this, I'll close. See, a document is confronted to the witness. If he admits the signature, the judge must be careful. Only the signature must be marked for identification, not the entire document. If he admits the contents of the document and also the signature, nothing wrong in giving an exhibit number to that and admitting in evidence. But take a case where the witness totally denies the document. What is to be done? Courtroom practice is whether the document is admitted or not, on the same day with a memo, it shall be filed into court. Not as an exhibit, but it shall be on the record of the court. The court must tomorrow know what is the document confronted to the witness and denied by the witness. The counsel cannot take back that document. But later, if that document is to be proved by the counsel, the client of that counsel, then a petition must be filed to formally receive it by granting leave as a document on record. Then the document can be proved through a witness. Otherwise, tomorrow there will be no record to show what document is confronted to the witness and denied by the witness. This is another important courtroom practice which is to be followed by all judges, in my humble view. These are some of the thoughts I wanted to share with you while renewing my association with all of you, sirs. I'm thankful for the opportunity given to me for sharing my humble thoughts and some of the courtroom practices.
Thank you. Thank
Then
you.
I will also deal with two more aspects before I close.
Sure, sir. Yes.
Before I close. One is a preliminary decree is passed in a partition suit. For a final decree, a petition is filed. A commissioner is appointed. He files a report saying that one property is not fit for partition. It is to be auctioned between the parties. If the parties are not willing, it should be partitioned in a public. It should be auctioned in a public auction. Then he also says that the remaining properties can be partitioned, and he gives a plan with metes and bounds. He files a final report. An application is filed to cross-examine him. Can it be permitted? I said in my decision that it cannot be permitted. He is doing a ministerial act, that's all. If you want to contradict, you can file objections. You can seek reappointment, reintrustment of the warrant, or you can ask some other commissioner to be appointed to know whether his opinion is correct or not if the facts and circumstances permit. This decision of mine was approved by the Supreme Court, saying that in such situations, no cross-examination at all. 2024 ALD 426, 2024 ALD 426. SLP number is 4176 of 2018, 4176 of 2018, decided on 19/2/18. I am told this is reported. Then another case, take it. An expert gave an opinion. He is a forensics lab science expert. A petition is filed for permission to cross-examine that expert by another expert. I said, no, it cannot be. See, an investigating officer need not be examined by a retired police officer. Is it necessary? A doctor need not be cross-examined by another doctor every time. Our advocates are competent. At best, they can be assisted by technical people when cross-examining is being done. My decision is 2014 3 ALT 578. Sir, so far as parties sailing together and they are required to do further examination in chief, I'll pass on the decision sharply.
Yes, sir. I'll share it with the group. No.
Right, sir. Right, sir.
So,
Thank you.
Thank you very much, sir. Before I go to Justice Ramashan, sir, only one question for the benefit of the participants as well. So you said that document could be confronted. If it's completely denied, it has to be marked because
It cannot be marked. It will be filed.
It has to be produced with a memo. Correct, sir. It has to be produced with a memo, and so that at a later stage, one would be able to know what exactly is the thing that was confronted and denied. Sir, my only doubt is that at times we come across a situation wherein the other side says that this ought to have been produced for confrontation. You just cannot take it out of the pocket and show to the witness. What is the correct procedure, sir, as far as confrontation of a document which is not on file? Should we produce it beforehand, or we can just show it while the witness is in the box?
Not necessary.
Order 13 says, any document can be produced. Last time there was a discussion on that.
Yes, sir. That is why, in continuation of that, I am just putting the question for the benefits of those who weren't there.
Then ultimately, you yourself has circulated a decision after my talk.
Correct, sir.
What is that decision? That CP
It can be done.
There is a decision rendered by the Supreme Court. Some bar association case.
Yes, sir. Yes, sir.
Salem Bar Association.
Yes. In that there is an answer, sir. Any document can be produced.
Correct.
There is no restriction. Straight away in cross-examination.
Correct.
Otherwise, what happens is, if he takes back the decision and wants to produce it, we don't know whether he's producing the same document or not.
Absolutely.
He will also say in the evidence, this document is confronted to the witness, he denied it, therefore I am producing it. We don't know whether the same document is confronted or not, is it not?
So, sir, for the purpose of confrontation, it should be with a memo, then and there. So,
Not necessary. When it is admitted,
you can mark it straight away.
So if it is admitted, it need not be marked at all because it's admission document.
Yeah, yes, sir. No, but documents admitted documents also must be marked. Otherwise, the court's attention will not be drawn to it when it will go as unfiled document, immaterial record. The court staff will put it in that record. So it is better to mark it.
Sir, on the basic premise that marking is not proving, it's only for easy reference, it has to be marked. It does not signify anything more other than it is to be referred to as A4 or B4 or B2 or whatever it is.
Sir, the most important here is orders 10, 11 and 12. Notice to admit documents. When we give notice to admit documents, their documents are admitted, we'll straight away mark them and proceed with the trial.
Absolutely, sir.
Proof is dispensed with, not marking.
No, marking is not proving. You can mark it. Marking is only for easy reference.
Marking is compulsory, but
Correct.
proof is dispensed with because admission is there.
Correct.
So, under our civil rules of practice, A series for the plaintiff, B series for the defendant, C series for court documents, X series for witnesses documents. C series is commissioner's report. Witness
Absolutely.
wrote something in the witness box. It is in C series because it will not be returned to anybody. It is a court's document. Plaintiff is confronted to the witness and his signature is admitted. Then plaintiff is a court document. It will not be returned to anybody. It is in C series. Like that, wakalat is confronted for comparison of a signature of the defendant on the promissory note. Then wakalat is also marked because court's attention must be drawn at the time of appreciation of evidence. Otherwise, the court will not look into the wakalat generally. So in the deposition, we'll mark the wakalat also, but in C series.
Correct, sir. Sir, one more query and then we'll go straight to Justice Ramakrishnan, sir. That is some evidence and no evidence. That is, I mean, if there is absolutely no evidence, but there is some evidence could be looked into. For the example, like, so you said you got a difficulty in getting expert opinion from the forensic laboratories. We face the same situation in Kerala, elsewhere also, not just Andhra or Telangana for that matter. So what happens is that an expert or an opinion is sought for from a private body, maybe through court or otherwise, and it is produced. Sir, even though it may not come under the definition strictly of an expert evidence, could it not be taken as yet another evidence which, if corroborated, otherwise could be sustained?
Yes, yes, it is true. But what is the sanctity of privately obtained opinion? See, supposing he gives his own document which is in a different handwriting, he designedly disguises his handwriting and gives that document for comparison. And then what is the document the defendant give to the expert for comparison? A photocopy, because the plaintiff's original is in the court. See, the expert, what is the document which is disputed, which is sent to the private expert? Only a photocopy. He is comparing a photocopy of the disputed document with the defendant supplied document, which is designedly which contains writing which is designedly disguised. Naturally, the report will be forgery. Is it not necessary that the original should be with the expert? If it is through court, the court will send the original promissory note to the expert.
So there again, if it is through court, even a private expert could be construed as an expert for all practical matters.
Yes, of course. Private experts, earlier, when FSL was taking only criminal matters, we were relying upon experts from Mumbai, is it not?
Yes.
Ashok Kashyap and all.
No, even otherwise, getting a result from the government laboratories will be taking time.
Okay.
So in order to avoid the delay also,
We
only
are-
thing is, after cross-examination of that witness, how can that witness can be relied on, or that can be possible.
That's a
Correct, sir. And on that aspect, one final query, and I'll pass on, sir. That is the other question that has come up is that if a private report has come, can it be said that the initial burden is discharged by that party and the honor shifts to the other party, and it is for him to bring some better evidence to dislodge this? Can such an argument be taken, sir?
See, sir, if it is generally the forgery plea will be by the defendant. By the time the plaintiff's evidence is already over, right? If the defendant produces, relies upon a will in the defense, and the plaintiff files an additional pleading and says the will is forgery, then also after the defendant's evidence only the burden is on the plaintiff. So it is always when a forgery plea is taken, the person who is saying it is forgery will be relying upon, will be adducing evidence after the first evidence is over, either the plaintiff or the defendant. So generally forgery evidence is a rebuttal evidence, because the burden of proof is on the person asserting, not denying. He who asserts must prove. So
Yes, sir.
then the defendant comes into box.
Section 101 to 103 of Evidence Act would apply. I agree, sir. Ramakrishnan, sir, your comments, please.
No, even the Seetharama Murti, sir,
Yes,
as
sir.
regards the last question also, suppose the burden is always on the plaintiff to prove that it is a document was executed.
Yes, sir. Yes, sir. Yes.
Suppose he denies the signature and he says it is a forgery. Is it not the primary burden on the plaintiff by sending the document to the laboratory and say it is all signed by?
No, it is, that is why it is said, number of the plaintiff is confident that his evidence is sufficient. He cannot be compelled to examine a witness. Number of witnesses is not relevant. Quality of evidence. He feels that his evidence is quality. he cannot be compelled. The court may
No, probably it may be possible. Suppose he himself says, and also the witnesses' documents also go to the box and say that we saw this other person who is signing it, etc. Execution is proved, he can say. Suppose the signature, then probably the burden will be on the other side, because he may be able to put a signature in a different way also for the purpose of with an intention to cheat. That also we cannot rule out at the time when the plaintiff was giving an evidence.
See, sir, in such situations, Section 3 operates is my humble view. Plaintiff says with his evidence, his case is proved. The defendant contends successfully that non-sending is a disproof. So, proof and disproof. If we believe that disproof is there, then plaintiff will lose. It's a matter of appreciation of evidence rather than compelling a witness to examine a witness.
The not even concept of adverse inference will come.
You can no adverse inference, not sending in the document.
The same thing, if you are confident that it's a forged document, why did you not send it? The same thing can be said of the defendant also.
Yes. That is the reason I said.
Ramashan sir, I think
ultimately it is appreciation of evidence.
I think the concept of he who asserts as to prove is that the person should be, nobody can be compelled to prove the negative. So I cannot prove that it is not forged. It is a person for who says forged to see to, I need only initially prove that it is in existence and I assert that it is a correct one. The person who asserts that it is a forged one has to take steps, I believe, subject to correction.
Probably you may be getting an further opportunity repeating that evidence in such cases.
Absolutely.
Is it not, sir?
Typically, it is not negative proof, sir. Where there is no possibility to adduce negative proof, that concept of negative proof comes. Not when there is a possibility to prove that the document is forged. We cannot bring it under the category of negative proof.
Right.
It is a positive proof. That is a forged document.
Yes, sir. Yes. Sir.
Or there is no possibility for him to sign is a different question. Suppose you are relying on a document which was signed by somebody else who is not the defendant, then probably all those things may come into existence for the purpose of appreciation as to whether that particular person is would have been executed or not executed. Even in the case of will, it may come. Even in the case of will, it may come.
Sir, Mr. Shyam, negative proof, I can give you an illustration.
Tell me, sir.
Plaintiff says there is a document. He is unable to produce it. He cannot ask the defendant to say that there is no document at all. It is impossible to prove that there is no document. On the other hand, plaintiff can prove that there is a document.
Correct.
That is negative proof.
Absolutely, sir. I got that. Ramashan sir, anything to be added?
No, it's a when Seetharama Murti sir makes a thing, he never gives any room for any question. He explains with all examples and also possible the possibilities of other questions that is likely to come. All practical aspects he has covered. Thank you very much, Mr. Seetharama sir. Nice presentation.
Thank you, Justice Ramashan sir. Girdhar sir, please.
Thank you, Justice Murti. It was. I'm more of an appellate lawyer, having done limited trials, and a writ lawyer. So your presentation was excellent, and it was a great learning for me. I just have one question that relates to examination of expert. I mean, in relation to signature. Suppose during cross-examination of the plaintiff, who relies on an exhibit on a document which the defendant alleges forged, we compare some admit. Let's say I take his wakalat and cross-examine him and point out that there are differences. Now, to a naked eye, there may be differences which the plaintiff may or may not admit. Now, the plaintiff may assert, but to the naked eye, the differences are obvious. Then during trial, suppose the plaintiff, neither of the parties examine expert evidence, a handwriting expert, then don't you think that the defendant would prevail in such cases and the court would distinctly note the absence of summoning of an expert evidence by the plaintiff?
Sir, here we have to maintain a distinction. The defendant's defense is forgery. He brings in a document which is a contemporaneous document to that of the document which is in dispute. See, promissory note is of the year 2018. He brings his own document of the year 2018 and then produces it in court and for comparison. Then there are differences in the signature and the writing. Then it has more evidentiary value. supposing he relies upon only his wakalat, he knows his defense is forgery. Therefore, he may designedly disguise his signature on the wakalat and bring in some variations in his signature so that he can, by comparison, he can show that the original is forged. In such situation, this latter wakalat, which is filed with an intention to show, to support his defense, may not have that much of credence as a documentary evidence. That's how the trial court judges who are experienced will appreciate the evidence.
If on the other hand, there are two contemporaneous documents filed, one of which a forgery is alleged, if the defendant's lawyer cross-examines showing the plaintiff's own other exhibit and highlights the differences, in the absence of a handwriting expert, wouldn't the court conclude that, draw an adverse inference?
Section 73 of the Evidence Act, the court is an expert of experts. The court can compare the signatures, but while appreciating the cross-examination, the court will study the law and see whether the variations are natural variations. With the age, advancement of the age, the support which he has when he is signing the document, the pen which is used to sign the make the signature on the original and also on the document which is produced by the defendant, all these aspects will be borne in mind by the judge while appreciating the evidence. There may be some natural variations which may be brought in evidence. They may not outweigh the evidence of the plaintiff.
But that could be noted better by an expert than a judge, isn't it?
The court may suo moto send it at the appropriate time. The court has always that right to call any evidence. Or the court may, in such situations, ask the plaintiff, why did you not seek an expert opinion? Then the court may, in some cases, there are instances where the appellate courts remanded the matter also.
Thank you, sir. Thank you.
Murti sir, would it not be correct as a part of that answer? I'm just airing my thought in the sense like the party who would fail if no evidence is adduced should take steps. Could we not view in that manner also?
No, not that. The question is not that.
Not adducing evidence. He already adduced evidence. He is satisfied with the quality of evidence he adduced.
Absolutely.
Well, not only that, both the documents were there. One admitted by the defendant of contemporaneous state and one the disputed document.
Yes, sir. Yes, sir.
Court can compare it, or court itself can send it for a expert opinion as to whether the admitted contemporaneous document these are being signed by the same person or not.
Correct, sir. Before going to Dilip, sir, can we have Aparna Lakshmi, please? Go ahead.
May I please, Milad? Milad, namaste, Milad. Milad, one small submission, Milad. I am having one doubt, Milad, that Milad, where there was a dispute with regard to the execution of will and its genuinity, Milad, plaintiff can file application under section 45, read with section 73 of Indian Act, Milad, Indian Evidence Act, Milad.
See, mere sending a document for proof of a will is not sufficient. Even the expert says it is the executed by the executant. It may not be proper proof for the reason that it is a compulsorily attestable document. Attestar must be invariably examined. And the law says attestation by two witnesses is attestation. If one attestar is examined, he does not speak about the other attestation, then it is no proof of attestation of the will. The only attestar examined must be able to prove the attestation by the other witnesses also when the two witnesses attested at one point of time. If they attested at different points of time, all the two attestars must be examined. Otherwise, attestation of the will by two witnesses is not proved. And this opinion evidence, when it is solved by this, one of the parties, it is only a corroborative piece of evidence rather than the main piece of evidence. The main piece of evidence is the evidence of the attestors.
Deeply obliged.
Sir, the procedure for proving a will specifically is spelled out in section 68, 69, etc. I think that has to be followed and that cannot be substituted in any manner.
Yes.
Dilip,
and then,
please, sir. Murti, sir, you were saying something. Please continue, sir.
Yes, sir. So far as a will, two witnesses must be examined. Otherwise, there is no proper proof of the will. I want to give a decision. AR 2003 Supreme Court 761. year 2003 Supreme Court 761, 2008 15 SCC 365.
Year 2003, what's SC, what's that?
2003 SC Supreme Court 761.
Thank you.
And then 2008 15 SCC 365. Attestation by 2 witnesses is compulsory and that must be proved. Mere examining one witness who doesn't speak of the other attestation is not sufficient.
But if a single witness speaks of the attestation of both witnesses, isn't that?
That is enough. That is enough. You must be able to say both were present at the time, both were seeing each other signing it. That is enough. That must also come on record. That's all.
Yes, yes.
Good afternoon, sir. Namaste. This was a very erudite articulation. And sir, first of all, I'll ask you, try to explain a situation where a plaintiff filed a suit on something related to aquaculture. And this
Question relates to, sir, I am not able.
Aquaculture.
Aquaculture. Yes, yes.
And urgent commission was also taken out to report on the matters enlisted in the commission application with the aid of an expert. And expert was also provided, who was a professor in aquaculture. So he filed a report. And at the time of trial, it so happened that the expert cannot be traced out. He is not there, whether he is alive or not is also not. But the commission report contains his report as the commission was examined. And she could only say that he also was present and he prepared the report. So in order to prove the contents of the document, that report, his examination is also very, very much necessary. When in such a situation, what is the option for the plaintiff? Can another expert of the same standard can be summoned to opine on the report filed by the earlier expert?
Then is it not covered by section 32? Persons who cannot be called as witnesses, persons who are dead, persons who cannot be found, persons who have become incapable of giving evidence, persons whose attendance cannot be procured without amount of delay and expenses. I think you can bring this evidence under this category and take it as an opinion. But then, of course,
The proof of the
proof, yes, of course, it can be taken as evidence.
yes, but
What evidentiary value will be attached to it is a different matter.
yes. So what is the option for the plaintiff?
An exhibit,
Yes,
I think there is section 32 comes into play.
sir. That is with regard to the admissibility. That can be can be
It's
taken as-
admissible and also relevant.
yes, but to prove for the proof of that report. My question is whether an equally important or an expert, another expert who is well versed in the subject can be called in.
See, sir, an opinion is by itself not evidence.
Yes.
Opinion is always supported by reasons. The reasons are given in the report in support of the concluding final opinion, is it not? The reasons are always there. Another expert can be examined. Supposing a post-mortem report is given.
Yes.
The doctor died. Can't another doctor come and speak of the report?
Yes. Yes.
Isn't so? Another expert in the field may come and depose.
Okay.
Both sides can examine. Both sides can examine expert and prove that this opinion is wrong, opinion is right.
Right. Is there any provision, specific provision?
Only 32. Only 32.
See, even in such cases, he can only prove that he knows the signature of that person and also the probable conclusion that has come out. What is the procedure conducted, etc. Contents of the document, he may not be able to prove.
But
Probably.
you can say that on these reasons, this opinion is possible.
Yes.
Ramashan sir, even the signature identification may not be necessary because he is only speaking about the reason, the foundation of the expert opinion. If he can independently with empirical other data, he can say so.
Even that signature also can be proved by a junior doctor if it is a post-mortem opinion who has seen his signature number of times, or the student of that expert, aqua field expert who has seen the signature of his professor, he can also come and speak about the signature also.
Yes.
Murthy sir, in this one, the signature may not assume importance because the commissioner, they both went and the report is on file, and that signature may not be in dispute in this case because it's a court document.
It's all right. If the signature is disputed, it can be proved by
Correct.
person.
Absolutely.
Then I have another question, which is related to the subject matter of discussion. That is, the right to begin means an obligation to start, right? Right to begin for a side is also an obligation to start.
Class, you have to take the children.
Then, in criminal cases, usually the trial starts with the examination of the witnesses, and he will be cross-examined, or the statement would be marked the subject of proof, and he would be cross-examined by the accused counsel, and he will be tried to be contradicted as to the part of the statement which he has made. And thereafter only the prosecution team would be examined, the investigation officer or other officers who had been part of the investigation would be examined. Is it not contrary to the proviso to section 162(1) of here? Because 162(1) speaks that provided that when any witness is called for the prosecution in such inquiry or trial, whose statement has been reduced into writing as aforesaid, any part of his statement, if duly proved, that emphasis I am give emphasis on this, if duly proved, may be used by the accused and within the permission of the court with the permission of the court by the prosecution to contradict such witness in the manner provided by section 145 of the Indian Evidence Act. So only if the statement has been duly proved, it could be used in contradiction or to contradict.
No, that proof is, Mr. Dilip, when the witness is examined, you will be saying that I have been questioned by the witness. I stated so before the police. So only if there is a contradiction is there, you are using this previous statement of the case diary statement and putting it to that. Is it not the contradiction? Is it not the way you said? Not you are differently saying in the court. That's only for that purpose. The 161 statement can be used by virtue of 162 proviso. That's all.
No, 162 statement says that such statement shall not be used for any purpose.
See,
no, any purpose other than for contradiction and corroboration. That's all.
Yes.
IO will be examined in the end. He will prove the omissions and contradictions. There the proof comes. Only if the witness is confronted, you did not say like this to the police omission. If it's a material omission, it's a contradiction. It will be noted in the deposition. When the investigating officer comes, then he did not say so before you, the cross-examination will be done, then it becomes part of the evidence. That is proof.
My doubt is, if the statement is duly proved, could that be used for contradiction?
That due proof comes from supposing witness said, I was present and I saw from behind a tree. In the cross-exam, in the deposition, he says before the court, that is the statement recorded. From behind the tree, he has seen the incident. When it comes to court, he was behind a wall and saw the incident is the evidence. There is a contradiction. Then you ask him in the cross-examination, you did not say so before the police that you are behind a wall. Then he says, no, I did not state, I only said that I was behind a wall. Then there is a contradiction, it will be marked because this statement shows he is behind a tree. Then the police officer comes, he will be confronted. The witness said like this, before a tree, behind a tree he was. Then this is evidence, the contradiction is proved. Till then the contradiction is not proved.
So the statement stands duly proved by the witness himself.
No, because the contradiction is proved when you are putting it to the witness. See, that is I think one of the decisions the Supreme Court says, merely because you prove the contradiction through the witness will not amount to evidence or discredit his evidence unless it has been put to the investigating officer who recorded it.
Yes. It becomes part of
and then you will have to mark it that is such and such statement has been given as according to the witness. Either he will deny it or accept it. That's a different thing.
So the statement has to be marked, sir?
No, normally what they will do is when the time of cross-examination, you will be giving a provisional marking. Contradiction D1, D2, D3, etc. Thereafter, you will put to the investigating officer such instead of reading everything, because you will have to, in fact, even when you are examining the investigating officer, you will have the sentence will not be read. Only thing is the entire need not be written. You can say start with, end with, but entire portion will be marked. That is a practice.
That's what I asked, because according to me, the proof comes only when the investigation is examined and the statement is marked to prove him.
No, that is the reason why, there is a contradiction. The judgment says you will have to give a provisional marking. Otherwise, you may not win. That is the reason why it's a practice. That's all.
Provisional marking is not this what is intended by the words if duly proved.
No, see, how can you prove it then? How will it come on record by the court?
That is a matter to be discussed.
No, that is the reason why I think there is a one decision by Justice But, which says you will have to give a provisional marking.
Yes, sir.
And thereafter that will have to be read over to the witness, the investigating officer, to prove such a contradiction is there.
In fact,
Yes,
Rajesh Raju says it is Tahsildar in case.
Provisional marking is marking for identification.
That's all.
So it's not duly proved.
Yes, yes. At that stage, it is
Not
not.
till it is put to the investigating officer, it is not proved. That is the reason why even the defense evidence, delay, even if the defense asks certain questions that you have not stated so, you have not stated so, etc. Suppose you did not put it to the investigating officer the same statements to get elicit whether it has been stated or not stated. Then even if you draw 100 contradictions, it will not become a contradiction.
My query, my doubt is only that the accused is entitled to contradict the witness as to the statement, part of his statement, only if that document has been previously proved through investigating officer.
See, 161 statement is not a document.
It's not a document. It's
because it is not signed.
Yes, it's a statement.
So that is only intended for the purpose of eliciting certain facts which is said to have been said to the Padman. That is the reason why the courts also said 161 statement is not evidence.
Yes. So
unless it is supported by the witness in the court, it is not evidence. What witness says before the court is evidence. That is the reason the question of contradiction arises.
Sir, my doubt is something else.
Otherwise, I will put it to you. You are a judicial officer.
Yes.
How will you?
I will ask the investigating officer to be first examined to prove these documents, these statements, duly proved.
No, the contradiction, if it comes, suppose he is declared hostile. Then yes. What you say is correct. See, this question arises only after this is over. You are also cross-examining them. It is a different thing.
Ramashan sir, Ramkumar sir would say that duly proved means proved in due course, not that it is a past or let us not note by the tense.
If duly proved.
Section 136 says that the mode of proof. Judge is having the power.
Correct.
If the relevancy of one alleged fact depends upon another alleged fact being first proved, the judge may, in his discretion, either permit evidence of the first fact to be given before the second fact is proved, or require evidence to be given on the second fact before evidence is given of the first fact.
See, I mentioned not regarding the proof. The accused is entitled to contradict the witness as to part of his statement only if the statement has been duly proved. That is my content.
What is the provision, sir, you pointed out from CRPC?
162(1) and proviso to 162(1).
That is answered by, I think Justice But has answered it. If you go through that provision, there is one decision, Justice But, how the contradictions will not be marked, how it will not be proved. You will have to follow the judge-made law for that purpose of explanation given. That is the only thing possible.
You might remember, I have asked the same question to Ramkumar sir also when he took up the class on contradiction. He said, he also asked Justice But as to how this will go together. And Justice But said, no more discussions, we will follow the suit.
That's the only thing possible. When a judge-made law is there, as to how this practical thing will be done, that you will have to go by that only.
I don't think there is specific finding ruling to this on this point?
I think so. I think if you read, I think there is a decision by justice, but I don't remember it. I think there is this where he has explained how the contradiction will be proved and how the contradiction will be recorded.
Sir, may I just what has been sent across to by Ramkumar sir? It says that.
Sir, Shyam Garu, one more point on this. See, the law says the statement is an unsigned statement. The witness, what is saying in the box may be more truth than the statement. There is no sanctity to that statement. So in 1959 Supreme Court, the Supreme Court said a witness in the box cannot be pinned down to the previous statement.
Yes.
He cannot be pinned down to the previous statement. So 1959 Supreme Court is an authority on that. AL 1959 Supreme Court. So my humble view is, even if the signature is admitted, it is inadmissible.
Here there is no signature.
Dilip sir, what Ramkumar sir has sent across is, if the witness admits the contradiction, that is proof. If he denies them, the proof should come from the investigating officer.
Correct, sir. Correct.
But to put it as a contradiction, is it not the law that the statement should be proved before that?
See, Mr. Dilip, you are relying on 167 statement on the premise that a statement has been recorded.
Yes.
So there is a document there said to be the previous statement of a witness.
Yes.
You want to discredit the witness on the basis of the statement that has been provided to you.
Yes.
So the witness goes to the witness box and says that I have been questioned by the witness, the police officer, I gave evidence, and he narrates what he has, because he cannot be asked to say whether you have stated so in 161. No, you can only, he is only narrating what he has seen, said to the police officer. Suppose you want to discredit him on the basis of the previous statement, you are putting certain questions or certain facts which is narrated by him, which is new or in contradiction to what was stated earlier.
Yes.
So if it is a new one, it will amount to omission.
Yes.
If it is an earlier statement, it will amount to contradiction. If a different statement is given than what is stated, it will be a contradiction.
Yes.
So once he says that I have given such a statement, but a different statement is given, then can straight away, if he admits that he has given a certain statement, but he has now changed his version, then it can be proved that the contradiction is proved. That's all.
I understand, sir. But my doubt is whether an accused is entitled to raise a contradiction.
No, if that be, Mr. Dilip, if that be the case, the whole difficulty will be you will have to examine the investigating officer first.
Yes.
And they will have to prove that I have recorded the statement of so and so. All the statement will have to be marked then. Then only the question of cross-examination arises. So that is not.
According to me, that is what the procedure code intends. That is
No.
humble view.
Sir, the statement reduced into writing only can be confronted. A statement not reduced into writing cannot be confronted.
Not, sir. What he says is, first of all, you have to prove that there is a 161 statement.
Yes.
Unless that statement is such a statement is there proved, who can prove it? He is according to him. You will have to examine the investigating officer. First say, I have examined so and so. So these are all the 161 statements.
Yes.
Even then, he is not entitled to prove the contents at that time.
Sir, then we'll go by the presumption, sir. Every official act has been done in accordance with the procedure. The presumption says it is recorded. So on that presumption, it is already there on the record. Then we will come to contradiction and then proof of the contradiction.
Then there would not have been any necessity for using this precise phrase, if duly proved.
No, presumption is a rebuttable presumption. Maybe he did not go to the witness and record the statement. That may come out in the evidence.
That's why I said, yes, a statement by the investigating officer as to this witness has come to me and has given a statement like this.
Yes.
Then only the accused can contradict that witness.
No, he need not, because there is a presumption that every official act has been done in the manner contemplated under law. 1959 Supreme Court 1012. 1959 Supreme Court 1012.
Sir,
on that presumption, the statement is already on record. Whether the presumption is rebuttable or not is a matter of evidence.
Yes, but that is subject to the limitation of having provided a particular way of trial or adducing evidence.
Dilip sir, on that point, let us stop on this way. That is, interpretation is possible in the manner you suggested or otherwise. But if it leads to an absurdity, are we not bound by the way it has been interpreted properly, or rather we assume to be properly by the courts?
And it's like followed like.
Absolutely. Otherwise, twice the investigating officer will have to enter the box. One is for this empty formality of proving, then whatever said by the concerned persons who are given the statement, then again to get an explanation from him, again he'll have to put in the box. That is asking too much on the procedural side.
But I think regarding the presumption of innocence is concerned, that is the way it should be.
The innocence presumption does not go. It's only on the regard the statement, authenticity of the statement. Innocence, the presumption remains. That is not at all affected, I believe. Let us also go. I mean, anything else, Dilip sir?
No, nothing.
Anil Mohammed, please.
Sir, whether a copy issued under the Right to Information Act can be marked as a secondary evidence.
Yes, sir.
Whether a copy issued under the Right to Information Act can be marked as a secondary evidence.
Why
Yes,
secondary
sir.
evidence?
The Act itself says, Right to Information Act itself says it can be admitted in evidence. I think there is a provision in that Act itself. They will give an attested copy, is it not? True copy, attested true copy.
Normally, they will make an endorsement only to the effect that issued under the RTI Act.
It
Only
is
to that much.
a public document, is it not?
But they will not certify the contents there.
Copies. No, they have to certify it as a true copy and give it, sir. They have to certify it as a true copy and give it. That is the requirement of the law.
The contents will have to be proved otherwise. I mean, contents, there is no proof of contents. It's only say that it's a copy of the other one. If the other one is a forged document, this will not get sanctified because you get a certified copy or a right to information copy.
See, that is why I will tell one more aspect so far as our judiciary is concerned. The provisions of Right to Information Act cannot be allowed to resort to when certified copies are to be given by an institution.
Correct.
Supposing there is a judgment, a third party wants a copy of the judgment. He has to file a third party affidavit as to why he needs the judgment and take a certified copy. In such a situation, he cannot resort to Right to Information Act. So where certified copy is admissible, RTI Act copy is inadmissible.
It will have to come under section 81 of the 81 of the Evidence Act.
Evidence Act. So where certified copy is impermissible, it's the correspondence between two officers of the government, or it is some file note in the government office. It is accessible to the public. You can take a true copy of it under the Right to Information Act. It is straight away admissible in evidence.
Correct, sir. And I don't think it can be said to be a secondary evidence because it's primary evidence of what you got, I believe. I don't know. Sir, how is it?
It's a copy of a public document. Therefore, it comes under that category.
Yes, sir. Thank you, Anil, for putting that question. Harshvardhan, can you please put the question? You'll have to unmute. Yes.
When a document has no relevancy, can it be allowed to be marked? Is my question, sir. Then leave it for appreciation.
No. It cannot be relevancy. Relevancy. When we receive a document as trial court judges, we record in the document received petition. Document is received subject to admissibility, relevancy, and proof. So relevancy, unless the document is relevant, it is inadmissible.
Now, my question is whether we can allow it to be marked and leave it at the end for appreciation.
No, unnecessarily. Why burden the record unnecessarily? It is inadmissible in evidence when it is not relevant.
Sir.
You cannot admit it because I will read that provision regarding relevancy. I have already pointed out the facts which are expressly declared in this chapter to be relevant and of which evidence is permitted may be classified, and in the following groups that I mentioned. So expressly declared as relevant only shall be admitted in evidence.
Obliged.
Not only that, normally a question will be put by the judge. What the purpose which you are producing the document? If it is unconnected with the facts of the case or nothing relevant for the purpose of deciding the issue, it not be marked also.
Yes, sir.
Correct. Radhakrishna Murti, please.
Yes, sir. Actually, I mean, the documents obtained under RTI Act, there is a division bench of AP High Court, it cannot be marked as piece of evidence. I don't know under what provision that they have given. I can give that citation.
Yes, sir.
Because right now someone has rightly asked me saying that the document obtained under RT Act cannot be marked as a secondary evidence. But one judgment said it can be marked as a secondary evidence. I don't know why it cannot be marked as a primary evidence. I mean, I need to go through that judgment. But division bench of AP High Court clearly held the documents obtained under RT Act cannot be marked as piece of evidence.
No, that means that depends upon the nature of the document you obtained.
Correct.
And no, I have a question, sir. This is with regard to that. See, many judgments have been cited with regard to the examination of the witnesses. So the will being a compulsory attestable document and all, if the witness is, I mean, what is he has to be examined before the court? That actually I would like to know. What? Because after entering into the witness box with regard to the will, what he has to, I mean, what he has to talk about.
Then what is the definition of attestation, sir? Let us see what is the definition of attestation.
Yes.
Attested in relation to an instrument means and shall be deemed always to have meant attested by two or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument.
Yes.
Or has seen or some other person sign the instrument in the presence and by the direction of the executant, or has received from the executant a personal acknowledgement of his signature or mark or of his signature of such other person, and each of whom has signed the instrument in the presence of the executant, but it shall not be necessary that more than one of such witnesses shall have been present at the same time, and no particular form of attestation shall be necessary.
Yes.
Then
so yes, so simply he has to say that I have signed, and the executant who has signed before me, another witness also signed, so and so person has signed. That's all. That is sufficient.
Only the execution of the document.
Sorry?
Execution
Only
means
the execution of the document, and also the sound state of mind of the witness has to say that he has understood and he has signed it.
sound
Yes.
state of mind.
That's what I mean, because some judgments and all, see, that they have gone into the contents and all those things and all. But recent Supreme Court judge that they need not aware of the content, isn't it?
Yes, sir. They need not be.
No, that depends upon no, suppose that depends upon the nature of the witness also, because in a case where a document has been executed, will has been executed,
Yes.
the near relative is also the person who is going to be affected by the will is also present. He signs it as an attester also.
Yes. No, he can't be. See, the beneficiary cannot be an attester. That is a judgment.
Not beneficiary. Not beneficiary.
Yes.
One of the heir who has been disinherited.
Huh.
Beneficiary cannot be attested. But a person who is disinherited can be a witness. Suppose he is also willing that it can be given to his brother. He signs as a witness. Then he is expected to know the contents also. Depends on the person who is signing it. That's all.
See, after the witnesses attestors arrived, the will is dictated by the testator. The attestors may know the contents of the will there.
May or may not, because not necessarily. That's what that the Supreme Court held. No, recently in respect of, especially only in respect of will only, that they have said he need not know the content. That's what that is 2000.
There is no compulsion.
The judgment that is rendered on 25th September 2019.
He's only attesting the execution. That's it.
Exactly. That is only to that extent that is sufficient. Then whatever the other judgments earlier, because in respect of that he has not properly said, or all those things and all, now it is no longer a good law in view of this, isn't it?
Yes, sir. Yes, sir. You're right. There is no compulsion that they should know.
Yes. Thank you. Thank you.
Thank you, Radhakrishna Murti. We'll take one more question. Advocate Vishwanathan, please.
Some connectivity problem, Radhakrishna Murti.
Yeah. You'll have to unmute, Mr. Advocate Vishwanathan, sir. You'll have to unmute.
One question. In courts, certain documents are marked subject to proof. How the court will look into that? documents are marked as exhibits, but subject to proof.
See, sir, a will is produced by the propounder. Whether the court writes in the deposition it is subject to proof or not, the propounder only produced the will and it is only marked just without any proof because it's a compulsorily attestable document. It is like a document, like a will is marked through the propounder, it is always subject to proof. If the attestor is examined and the proof is there, appreciation of evidence, the court will say that it is proved. Even if the attestor is examined and his evidence is not quality evidence, the court may say that the will is not proved. It all depends upon the latter part of the evidence.
Suppose it is not a will, any other document. Suppose it's an income certificate. Income certificate produced by petitioner. Or says that it is marked subject to proof. And there is no further evidence.
Sir, in a motor vehicle accident case,
yes,
it is the same thing is marked. The insurance company counsel says it is marked, it may he objects. Therefore, it is marked subject to proof. But in the cross-examination, no question is put that saying that it is a manipulated document, it is not issued by the office of the employer. Then no cross-examination is done. Even if it is stated in the chief examination, it is marked subject to proof. It is not disputed in the cross-examination. So what is stated in the chief examination is admitted, no further proof is necessary. Supposing in the cross-examination it is stated that it is a manipulated document, it is not given by the office, further proof is necessary.
Suppose there is no examination at all, no oral examination is held. Only documents have been marked in Motor Vehicles Act.
Admitted. Then chief is admitted.
Is admitted. Okay, thank you, sir.
Thank you, Advocate Vishwanathan, sir. Aparna, if you can make it fast, your last question. We are almost at 1 o'clock, please.
Yes. One doubt, Milad. The application under the expert opinion can file plaintiff or defendant, Milad?
Anybody can file it. Both parties.
Anybody can. Okay. Obliged. Obliged.
Arshad, Harsha, please. Yeah, fast.
Sir, for example, plaintiff has not filed any document in the beginning, and he files all the documents at the end of the fag end of the trial, that is during the course of argument, and those documents are rejected. Can the defendant rely on some of the documents which are in his favor?
Documents not exhibited, neither party can rely upon that.
No, sir, not like that. Plaintiff files around some documents at the end of the argument, at the time of the argument, and those documents are rejected, saying that they are not relevant. But somehow those few documents are in favor of defendant. Then can the defendant get them marked through himself or through the third person, sir?
Sir, may I clarify your question? If the documents are rejected on the ground that they are not relevant, the court cannot look into them because the court has come to the conclusion that the documents are relevant and therefore inadmissible. Supposing the documents are rejected on the ground that they are belatedly filed, leave is not granted, then even then also, because it is not part of the evidence which can be looked into, both parties cannot rely upon that document. If the defendant wants, he can reopen the evidence and mark the document. He can get the evidence reopened and then get the document marked.
Sir, it's like this. He files certain house tax receipts, which is showing that he has paid house tax. But at the back side of the house tax, it is written that you have paid house tax to the extent of your house. Then can I mark that?
Yes, of course. Defendant can recall the document which is filed by the plaintiff, which is not marked. The defendant can take advantage and then consent to its marking. And supposing the marking is given on the front side without confronting what is there on the back side content is not proved.
Sir.
Okay. So, sir, but once the court finds that it's not relevant for the list, not just for the plaintiff or the defendant, right?
Not relevant for the list, yes, that's all.
No, the question is not that, Ms. Murti. What I understood is, he files an application and belated it was dismissed. The application was dismissed. Reception of document is dismissed.
Yes.
Once it is dismissed, can it be possible for the defendant to rely on those documents which was not received at all.
Yes, he can give admitted evidence can be marked. Then he say, I admit the document, let it be marked. He can file a petition by reopening the case and ask the document to be exhibited.
No, that was not received at all. The application to receive document is dismissed.
Dismissed. He can ask the document. See, when it is not filed, the custody comes. Now the document is in the custody of the court. Anybody can ask the document to be marked by, of course, following the procedure.
No, is it not necessary to recall the document, the order rejecting the application to the extent of permitting him to use this document? Without the document,
it will be now received at the instance of the defendant, not at the instance of the plaintiff.
So we need to file petition for that, sir?
Yes, yes. Reopen the evidence and then receive the document on behalf of the defendant and exhibit it.
Convince the court that it is relevant, because already a finding of not being relevant is there, like Ramashan sir said.
If it's already not relevant, then not be possible.
It's not possible. Yes.
Suppose it is belatedly filed, I am not receiving it, dismissed.
Correct. I mean, Harsha's question was that it's already dismissed, finding that it's not relevant. So it's
No,
not relevant for the case.
I don't think that he cannot.
He cannot. Only CRP must be filed.
No, not only that. Probably even the defendant would have objected it.
My question is both sides, sir. On both sides.
Defendant also would have objected not to receive it because it has been produced belatedly.
Correct,
Yes.
correct. And then later on, you cannot turn around and say that please accept it for its
Some of
beneficial.
the documents are in my favor, so I want to rely on it. No.
Absolutely. So thank you very much. We didn't know the time has reached even 1 o'clock, and even Ramashan sir did not say anything about food because of the involvement in the discussions.
Crosses 1 o'clock only I will say. If it crosses 1 o'clock only I will say. Just like in a seminar, putting the bell.
Correct. Sir. So as we come to the end of the 259th session, a Sunday morning well spent, and I would say such a forensic treat on such a wonderful subject, in depth, different contours, different dimensions, the kind of questions, the interaction, a wonderful morning, sir. I mean, no wonder we have been missing you so much in this platform for such a long time. And even in fact, when it was said that you are addressing today, the first remark of Ramkumar sir was that, oh my, I won't be able to attend, and see to that it is uploaded at the earliest. And for his remote presence today, in the sense like he has been sending messages, hearing your presentation, I think he is on his way back from the function he was attending. So that is the kind of interest that is being evinced by the participants, and we would like to have you more often on this platform, sir. And this subject cannot be covered in one session. We are fully conscious of that. Let us take it part by part and have in-depth analysis of different nuances of this thing. And I'm sure that you will accommodate our request and be part of this platform, sir. Thank you very much, sir, for sparing your time. I'm sure that your new assignment takes a lot of your time and effort, because that is a field I'm very dear to your heart, in the sense like human rights violations are happening, and correcting it and exercising your jurisdiction, that too when there is no definite guidelines regarding how the jurisdiction has to be exercised. And thanks to the full bench decision of the Madras High Court, we have got more strength in addressing the issues of human rights. Thank you very much, Justice Ramashan sir, and thanks are due to Justice Ramkumar sir also for his remote presence, I would say virtual presence, but being present and encouraging us with this webinar series. And all of you wonderful participants for being part and parcel of this wonderful journey. Till we meet again next week, do take care and stay safe. Thank you very much.